And now it's my pleasure to introduce to you our faculty. To your very far right, my far left, we're starting with Michael Schurz, who is Director of the Domestic Violence Project at Lawyers for Children. Before joining Lawyers for Children, Michael was Senior Staff Attorney and Coordinator of Training at New York Lawyers for the Public Interest. And prior to that, he led the Government Benefits and Special Litigation Units at the New York Legal Assistance Group. Next is Janet Sable, who's the first Deputy Attorney General for Affirmative Litigation in the New York State Attorney General's Office. Prior to her appointment in January of 2011, Ms. Sable was General Counsel and Chief Administrative Officer of the Legal Aid Society. Jennifer Croman is the Director of Pro Bono Practice at Cleary, Gottlieb, Steen and Hamilton in New York City. She originally joined the firm in 1996 and was a partner from 2003 to 2006, where her practice actually focused on commercial litigation. Prior to rejoining the firm, she served as the co-director of the Uncontested Divorce Project at Sanctuary for Families. Douglas Chu is a partner with the firm of Hines & Chu in New York City and Mineola, New York, where he specializes in elder law. Prior, he was the senior staff attorney for the Brookdale Center on Aging of Hunter College, specializing in Medicaid eligibility and government entitlements. Mr. Chu is a frequent speaker on elder law topics and co-chairs PLI's annual Elder Law Institute. Louis Sartori is the Director of Pro Bono Practice at the Legal Aid Society. The Pro Bono Practice partners with attorneys from the private bar to assist the Legal Aid Society staff in handling matters for thousands of clients in their civil, criminal defense, and juvenile rights practices. Prior to joining the Pro Bono Practice, Mr. Sartori was the attorney in charge of the Society's Manhattan and Staten Island juvenile rights trial offices. Finally, Bruce Green is the Lewis Stein Professor at Fordham Law School, where he directs the Lewis Stein federal prosecutor in the Southern District of New York, where he served as chief appellate attorney. He was also a judicial law clerk to Justice Thurgood Marshall and Circuit Judge James Oates. It's now my pleasure to turn the program over to Bruce Green. Thank you.
Thank you, Janet. Good morning, everyone. It's a pleasure to see you and a pleasure to be here. I think that this is our fifth or sixth. I've stopped, I can't remember anymore, but maybe fifth. So I think this is around the fifth time that we've done this end of the year ethics and pro bono program, and everybody on the panel has done at least one, and some have done almost all or all of them. And it's a lot of fun. And I thought I should start with a bit of a caveat. So we're going to basically discuss hypotheticals that raise ethics issues in the context of the kinds of representations that one might do in a pro bono matter. And I think every one of the hypotheticals has lots of subparts with lots of ethics issues. And it occurred to me coming here that if I saw this, I might never take a pro bono case. First of all, I would worry that I would spend my whole time resolving ethics issues and never actually get to help the client. And then I'd worry that I'd be putting my license at risk. So I think it's fair to say at the outset that we're doing this because we all have ethics CLE requirements, and that in real life, pro bono cases don't raise this many ethics issues so often. But nevertheless, there's always a possibility, and it's good to be sensitive to the issues. And so we're going to basically have a conversation with each other and with you. At the end of each segment, we invite you to raise your hands and ask us questions. And the people who are doing this virtually, I think, are also invited to ask questions. And we hope it's lively and interesting. So I'm going to start with the first set of scenarios, and it's at page 235 of the book if you're following along. And it's in the context of a pro bono immigration matter. And we have at least two people on the panel and maybe more who have experience doing immigration cases, so that's good. And basically the initial scenario is this. Your firm is doing immigration matters, and in one case there's a senior associate who's assigned to help get legal residence status for a man's wife. And so in the immigration law, it's actually the husband who applies for the legal residence status for the wife, and the associate does the filing. So far, so good. And then some time passes, and the wife comes in and meets individually with the associate, and she says that her husband's been beating her, she has a black eye, and that she wants to leave him. And she asks the associate whether the associate can apply for her to get legal residence status based on spousal abuse, and whether the associate will do that, because they're apparently that's one way to get legal residence status. And the question is, can the associate now do this? So this actually raises an interesting conflict of interest question. And the starting question is, as it is in a lot of conflict of interest questions, who's the client, or who was the client? And it turns out there's at least, I guess probably only 3 possibilities. And depending upon what the answer was initially and throughout the representation up to that point, you then get a different result in terms of how you deal with the conflict. So it's quite plausible that at the beginning, the husband was the client, because after all, the application is filed in his name, even though the beneficiary is the wife. He's the one who's signing the application. It looks like he's the party, and he may have been the client. And if there was an explicit attorney-client relationship with him, or even an implicit one, even if he was led to understand that he was the client and it wasn't made explicitly, then even if one would assume the representation is over, and certainly if he's still the client, you couldn't file for the immigration status for the wife based on spousal abuse without violating the conflict of interest rules, because the spousal abuse application is adverse to him. It makes an allegation that if you're the husband, I don't think you want to be made, although I understand the application would be confidential, but you'd basically be saying, representing the wife, saying, my husband is an abuser. And if you were the husband, you might well think of that as disloyal, I imagine you would, and filing that, at least without the husband's consent, which I don't think you're likely to get here, would be adverse to him. If he's a current client, the rule is 1.7, which says that you can't represent one client directly adverse to another current client. But if he's a former client, you still have a problem under Rule 1.9, which says you can't represent one client in the same matter or a substantially related matter to the one in which you represented the former client, if you're adverse to the former client. So you're adverse to the husband, it's the same or substantially related matter, that's a problem. Another alternative might be that they're co-clients. After all, when you first sought the application for the wife to get residence status, they were both going to be beneficiaries, and they both may have understood, it may have been explicit in your retainer, or may have just been implied in your dealings with them that they were clients. And if that's the case, then you still have the same problem, I think, that I just discussed, which is that you'd be representing one adversely to another who's also current or a former client. And so the only way you could do this, I think, is if from the very outset it was clear that only the wife is the client, and then you continued to act consistently with that understanding so that you never created an implied attorney-client relationship with the husband, which you could imagine doing, even if the retainer agreement said, I represent the wife, only the wife, and nobody but the wife. And it was provided to the husband, and it said, and I don't represent you, husband. You can imagine various times in the course of the representation where he might call with questions, where you might counsel him, where you might turn what was a non-relationship into an attorney-client relationship. So it's only if the wife from the very beginning and throughout was the one and only client, I think that you can do this. Now, I should pause, because I know there's a couple immigration lawyers on the panel to see.
Well, I would just add that that I absolutely agree with that outcome, but that this is not uncommon in immigration cases, because in immigration proceedings, it is often the case that family members are involved in your applications for the immigrant's applications for relief, and sometimes it's in the name of the immigrant, and sometimes it's in the name of the U.S. citizen. So a good practice rule would be to establish right from the beginning with the parties present who is the client, just always, and to choose, if you can. I mean, it was generally my practice at Legal Aid to say that we should try to represent where we could the immigrant, because that was the person whose life was going to be changing. And to work out a conversation, because often the immigrant was not the person who spoke English fluently, was often not the person who was paying for the application fees. Sure. Okay. I hope you can hear me or heard me. So I think that it's a good practice before problems come up to just have a routine that you apply in establishing the attorney-client relationship very explicitly in the beginning.
So I agree. The one thing is, in this hypo, the application is already pending, so you would have already filed something with USCIS saying that you're the husband's lawyer, because you would have had to have filed the G28 form when you filed the application. So I think it would be unreasonable, really, to take the position that you're only counsel to the wife when you've taken the position that you're counsel to the husband before the immigration proceeding. So sometimes you're a little constrained by who you represent because of what you need to file with the court or the immigration services too.
The materials have an opinion from which the hypothetical is lifted from the New York State Bar Association from 2003. It's at page 241 of the material. And I think you make a point that may either not have been true at the time or was lost on the committee, because the ethics committee, the State Bar, assumed that you could represent exclusively the wife. But it seems to me that if you have to file a document saying I represent the husband, then that wouldn't be viable. Could you file the document? Could you prepare the document as a lawyer for the wife and then give it to the husband and let the husband file it? And
Yes.
he's sort of the third-party beneficiary?
Yes, you can.
You can.
Okay. So I guess maybe the assumption was true. So I understand, you don't have to, under the, at least under the ABA model rules, have a retainer agreement. So you don't even have to have a writing necessarily that says you're the client, I'm going to represent you. Although in New York, at least, if it's a fee-paying matter and it's over a certain amount, you have to have that agreement. But even if you have that agreement, that's with your client. The problem here, in part, is letting non-clients know that they're non-clients. I assume lawyers, routinely do retainer agreements. Do they do non-retainer agreements? I represent your spouse and not you. It could come up in basically every context, a joint venture or, contracting. Anytime you're dealing with a third party who might ask you a question and doesn't have their own lawyer, there's at least some risk that they're going to think you're looking out for them. Do people routinely do that?
We don't do it in writing, but we would, we do a lot of derivative petitions, and we've had a lot of clients change their minds. So they have the status, and they say they're going to bring over a spouse or a child, and then the years tick by, and they no longer want the spouse to come over from wherever they are. If we have to talk to the spouse, which we do to get the information to file the petition, or we're meeting because the spouse is here already, we will start every meeting with, we represent so-and-so, we are not your lawyer. If you have legal questions, you should consult your own lawyer. But we haven't, it's interesting, we haven't ever done sort of a non-retainer in writing where we've said or made them sign something saying that they understand that we're not their lawyer.
I once did a program called something like the 5 top ways to commit malpractice, and this was the, one of the top 5 was, not making clear who the client is and isn't. And it struck me because there are quite a number of, these are not pro bono cases. These are cases where there's, big money at stake, where, malpractice and breach of fiduciary duty cases brought by people who said, well, I thought you represented me. And it always strikes me that, for the cost of a stamp and a piece of paper, you could have avoided the whole problem. And yet I guess people don't routinely do that.
No, and later on, I'm going to be talking in elder law, the same thing. We have many people with diminished capacity or older who bring in their whole family members and their social workers and their powers of attorney and their trustees. And, you bring up the point that, well, maybe, we're going to emphasize doing retainers and putting things in writing, but you don't want to go overboard because you can, as you said at the beginning, you can just frighten everyone. There's so many ethical problems here that they don't even want to come and talk to you ever because you have to sign all these pieces of paper releasing them and saying this and that. So I think it's a matter of experience, in hindsight from all us having all this experience, that you start to say things in advance and make sure things are made very clear verbally so that these questions don't get raised so that you say, oh, I wish I'd put this in writing, hopefully.
Another question that people often think of advance in the commercial practice is advance waivers. And so in theory, if you'd anticipated that, halfway through the representation, the wife was going to come to you and say that she was being abused by her husband, which seems like an unlikely thing to anticipate, you could have, even assuming you were representing him or both of them, put in the agreement some kind of advance waiver of the conflict. In the event that a conflict arises between the two of you, I will represent the wife and jettison the husband or something like that. Does anyone do that in pro bono cases?
We have an advance waiver in all of our engagement letters, pro bono and paying.
Oh,
But
what does it say?
it typically says that in the event that we represent both of you, and in the event that a conflict arises, you both give permission for us to represent either one, and will not challenge that. I have to say, neither in the paying context nor in the pro bono context have I seen us rely just on that. So I don't know that we would.
And I could say, in my experience, it varies from firm to firm, whether that language is in the retainers as well. We do have one question from the webcast, and the person is suggesting, could you have a second attorney appointed to represent the wife, and then continue to represent the husband? And so I'm wondering what folks think about that.
So let's suppose you think I can't represent the wife because the husband is a client. Can you help her get a lawyer, or would that be betraying the husband who's your client?
I would always help someone get a lawyer, just to make sure that they land on their feet, especially a pro bono client who doesn't have means and doesn't have access to, comb the market themselves.
And let's suppose...
I absolutely agree with that you would want to advise them that they should get legal counsel.
Okay, so now you have a piece of information that the husband, your client, might like to know, which is that the wife is planning to leave him, to file separately, et cetera, and is accusing him of abuse. Do you have a duty to tell the husband that? Can you tell the husband that? Or do you have some kind of implicit confidentiality relationship with the wife that trumps? I mean, ordinarily, as an agent of a client, if he's a current client, you have a duty to tell the client things that are material to the representation, things the client would want to know, I would think.
You obtained this information while you were representing both of them. And so it was during that representation when you had the confidential communications from the wife, which I think means that you then don't have the option of telling the husband.
So now you're sitting with some information that your client would want to know that you think you can't tell him because it's confidential. Do you have a conflict of interest that makes you no longer represent the husband? Do you have to tell him, assuming you never ended the representation before, I have to bring the representation to an end because I have a conflict? And if he asks you what the conflict is, do you say?
Well, it's an interesting question because if the wife is going on her separate track, the viability of the application that you're talking about is, it's no longer viable, right? So there's a bigger problem about who knows what. So I think in that case, you would say there's a problem with your application at the appropriate time, but presumably, I think in most cases, the client would know that there was a problem going on.
So the other half of this hypothetical, it raises a confidentiality issue. So this was just a fascinating representation, as you see. And so the associate decides to write a law journal article about it. And also the firm's marketing director, who wants to get maximum benefit out of the firm's great pro bono work, decides to post something about the matter on the website and in other material promoting the firm. And they won't include the names of the spouses. And the question is whether that's okay. And so this raises the duty of confidentiality, which exists not only during the representation but continues, forever. You have a duty to keep the client's confidences. And at least for my students, sometimes they think it applies only to the attorney-client privilege because they were so excited in evidence when they actually learned the attorney-client privilege. But the duty of confidentiality, as you know, goes much further and applies to any information relating to the representation. New York has its own little complex twist on this and slightly narrows the amount of the information so that if it's completely innocuous and the client hasn't asked you to keep it confidential, you might not have to. But in general, nationally, it applies to anything you've learned during the representation. And some lawyers might think, well, if I don't disclose the names of the clients, I'm not disclosing the confidences. And so as I travel the world, going to bar associations, telling stories about my cases, or drinking at the bar, telling stories about my cases, or blogging and writing and twittering.
Or preparing hypos for PLI ethics.
Exactly. Right. This is not certainly not my case because I don't do this work. You might think that, as long as you don't use the names, that's okay, but that's not right. And so there are a number of bar association opinions, including one recently from the New York State Bar that talked about whether a lawyer could write a book about his cases. I don't know that the book would be a bestseller anyway, but it basically said, if there's any possibility that anybody could, identify who the client is, if there's enough identifying detail that somebody could put two and two together, then you can't write this stuff. And so I imagine, in this case, the firm probably doesn't take that many of these immigration cases, and there's always a possibility. And think about if you were the client and you read this, how you'd feel about it. I think you might feel somewhat betrayed, even if your name isn't in it. And so I think you have to be pretty cautious. Now, you could always disclose stuff with clients' informed consent, but if it's contrary to the client's interests, to seek consent, it seems to me, is not a fair thing to do. So, and yet at the same time, we all have this burning need to tell the world about what we're doing, to blog, to market, et cetera. So what do you do about this?
Well, I know clients can be very sensitive. I mean, like I have a story that, I do a lot of probate because of elder law, and one of my, I always kind of have a record keeping in my head about like what's the longest probate I've had to deal with, to tell my clients the horror stories. And, one of them like went for, like 7 years. And one of the, I was dealing, my record was like about 7 years, and it was for an aunt, and I was talking to the nephew later on, and I said, your aunt's case is my prime example now of, why to avoid doing such and such or having a will or so on. And there was a dead silence for a minute, and he goes, "You're not telling everyone about my aunt's case, are you?" He was really upset. And I said, no. I said, this is just a very generic comment. I tell people, I've had a case, it took 7 years. And in back of my mind, I'm referring to your aunt's case. I know it, but I'm not telling anyone. So, but just by even just that little bit, he got very upset that maybe I was telling everyone about his particular aunt's case. So you do have to be sensitive to that.
I have these debates with people, though, because, people think that there's some, I don't know if it's a de minimis exception or drinking at the bar or going out with friends or talking to your spouse exception or something to confidentiality. Is there, I think there's actually some suggestion, if I remember correctly, in the restatement of the law governing lawyers about this. They don't take as strict a view as the rules on their face do, that if you can talk about something and it's not going to really come back to bite the client, that's okay.
How would you ever know unless
How
it
would
does
you-
come back to bite the client? Right? It's if you don't get caught, I guess.
It's not a
Your
problem
hand in the
till it is a
jar until
problem.
you're caught.
But it is what most of us do during our waking hours, except for me, which is represent clients. And so if you can't talk about your work, that becomes quite a challenge.
I mean,
become
I
blind.
do think also some of it is we like to talk about our work, but some of it is in pro bono cases, it's important to talk about our work because it's important to, I mean, sadly, a lot of battered women don't know that VAWA exists. And it is important, maybe not on your firm's website in a bragging way, but as an example, without names, to show, non-citizens who are stuck in abusive marriages that you don't have to stay with your abusive spouse because this immigration relief does exist. And changing the names and doing it as sort of a case study in an outreach brochure, right, in certain communities has a very different feel than kind of posting it on your website. And is that a problem? Right, because then it's less likely to be traced. I mean, there's an all too common scenario, actually. Maybe not for a specific law firm, but in this country.
Oh, and elder law, I mean, I'm just
Right.
thinking about this, you bring this up. I mean, I think in almost every consultation that I can think of, when I hear the scenarios and they're asking my opinion of which way to go, I bring a hypo out. And I tell them a hypo, and it's based on real life. I don't disclose any
Right.
people. But, and I tell them, well, this is what can happen. And their eyes light up, and it really can help steer them. And not that I'm trying to tell them what to do, but it steers them to make the right decision, because as I tell them, I'm your guide, I'm here to educate you, and this is what can happen, this is what happened to someone else, or if you do it this way, this is what happened to someone else. And it does help them make an ultimate decision, through using hypotheticals. So, yes, I do it all the time,
Yeah.
I guess.
So there's another webcast question. So as we bring this segment to a close, let's do this question, then if anybody live has a question. Are there any other downsides to using a non-representation letter other than scaring your clients away with all the procedural red tape? What do you folks think? It's time-consuming.
Well, how could you ever include everything in
Right.
I mean, the thing would go on forever. I don't know. Would it? I mean,
I think there are contexts where it's important to do. So a client comes and visits you and asks you to represent her, and then you decide for whatever reason, lack of expertise or time or resources, you're not going to take the matter, but they've left you with documents and they've left you with their hopes, and they're hoping that you'll take the matter. And you in your mind, you never agreed to take it, and so you don't think there's anything more to do. But in their mind, you're their hope. I think in that case, it's important to do something and memorialize it, to say, I can't take your matter.
I think it's an interesting question. I've never done it, so I haven't thought it through. But the problem that I could see is that over the course of the relationship, you might have this non-client letter, but in fact, subsequently establish an attorney-client relationship, right? You might sort of break your own rule as the lawyer and engage with the client in a number of ways. And so really, it's not going to solve all the problems about creating confusion. It just is a good marker, could be a good marker to say this is how we're setting up in the beginning. I mean, to go back to this attorney, like who's the client, I think we can go well beyond the immigration or the elder law context, because we have to all the time ask someone to leave the room when we're having a conversation with our client, because otherwise we'll breach the attorney-client privilege. And I find that creates a lot of confusion on the part of the family member who wants to sit there, or the friend who wants to sit there to support the client, and then they're being told, no, you have to leave. And that's sort of the first time, I think, where a lot of people have to engage in that conversation. But it happens all the time.
So one other quick question was about the advance waiver and whether they've ever been litigated. I'm sure that PLI must have tons of programs on conflicts of interest in other contexts. And so It's more likely to be in the commercial context where people have litigated advanced waivers, and there's actually a fair number of court cases, some of which have upheld them and some haven't. Nobody thinks in theory you can't have an advance waiver. The question is whether the particular one is detailed enough, whether the person who gave the waiver understood that exactly what they were waiving. Any questions in the audience before we move on to now we get to do some game playing, right, Lou?
Yes. So the second hypothetical focuses on limited scope representation, and I offered to take this one for two reasons. One, there's an article in your materials by Phil Genti, and I suggest if you haven't read it that you do, because I think it is very thoughtful and does give warnings without scaring you about taking on these. And the second is, these have become wildly popular, limited scope representations, for folks who want to do pro bono work, and there's a number of reasons why. One is that folks are busier, and so they don't necessarily want to take on longer cases that take a longer time. The second thing is that certainly here in New York, and I think in other places as well, there's been a push towards a concept known as unbundled legal services. So my background with legal aid was primarily, before I took this role, in criminal defense and juvenile rights, and there's a right to counsel in those areas. So I didn't really have a feel for civil work. So I went to a conference once, and when I started this position, and there was a whole conference session on unbundled legal services. So, of course, I ran back to my office, like we all do after we go to a conference, full of piss and vinegar. Can I say piss and vinegar on the webcast? Yeah. Full of piss and vinegar.
It is bleeped you. It is bleeped you.
To get this going, and I rush up to my civil colleagues and I say, we should do unbundled legal services. Silence.
Unbundled legal services.
We don't do those. That's not something that we do. Now, little did I know, it's the way that it's packaged. You don't buy a used car anymore. You buy a certified pre-owned car. And so it's important that it's clear, the limited scope representations, you're not seeing a client with 7 needs and plucking the one that's easiest for you to do. Now, there are models, and legal aid uses them, other providers uses them, Bronx Defenders and others, holistic services, and that's what we try and focus on. But when emergent situations come up or new issues come up, there's a need to deal with a lot of clients in a quick way, but in a way that meets their legal needs. And so limited scope representation is one of the ways in which we're able to do that. So real quickly with this hypothetical, we have an associate from a firm that is very committed to doing pro bono work. They want to have a signature project. And there's a new program that the county has put together to allow folks to apply for a rent income exemption. And basically what the program does is it allows folks to if they have an increase in their rent, they get, let's just call it a voucher, and then that voucher can be used by the landlord to offset tax costs. So the rent stays, the landlord is still getting the same amount of rent, they're just getting it in a different way. So the particular legal service provider sets up a clinic. At the clinic, people are pre-screened by the legal service provider. They come in, and the volunteers help them filling out the forms. And generally, even though they've pre-scheduled all of the attendees, some folks don't show, and others show up who don't have an appointment. One of those is our friend Sammy, and he gets into this CPR. He meets with the CPR associate Annie, and she explains about the situation with income and how free works. And free is the name of the program. I go through a lot of trouble with these abbreviations, so I hope you people appreciate that the names, the help, and CPR. But Sammy was not screened, and he goes over the qualifications with him, including income, explains how it works. He assures her that his income qualifies, but he doesn't have any of the documentation. So she helps him with the form, highlights what he'll need to do to attach, and sends it off. A few months later, Annie hears from the folks at the legal service provider, and the application had been approved, but Sammy's employer finds out that he has applied for this, and he's the super in a building. And as the super in the building, his rent is part of his income because he's given a free apartment there. And so that wasn't included in the application. So the landlord becomes furious, fires him from the job as the super, and begins eviction proceedings. So I think we're going to go now to the polling. And the first question in the hypo is, have Annie and CPR, the law firm, entered into an attorney-client relationship with Sammy? And so if you can just take a second, if it's up there on your screen, and vote. Oh, and here they come.
Oh, how many people are voting? Yeah.
Yeah. Wow.
That's good.
They're voting at home too, right?
That means
I don't know if
I
they're voting
presume
at
they're-
home, but
people took Janet seriously when she said, you know, you
Wow.
can't go to the internet.
well, the folks at home are certainly voting.
Oh, see.
Is there a cutoff time?
Yeah, we're going to have to cut it off at some point, maybe at 300.
Yeah. I think you're past 300.
Yeah, I am.
It's like a telethon. Watching the dollars
Yeah.
roll in.
And, okay, here we go, sorry.
Show results. Can
Yep.
you click up there?
Yep. Okay. So interesting. So 52% say yes. 34% say maybe, probably shouldn't have given you that option. And 14% say no. The answer is no. This was a limited scope representation, and there is a rule, Model Rule 6.5, that deals with this. But the real better practice here would have been for the client to sign a limited scope retainer. And a sample of one is in your materials, but it basically discusses with the client that you're not taking on the full representation, that you are, and we don't even call it a retainer, we call it an agreement, because you're not being retained and you're not taking on full representation. And I think that from the public interest point of view, it's an important document because our clients are coming in quickly and they're seeing us for an emergent need, and we want to be clear with them that we're, at this point, assisting them on only this one particular issue. It's also a very important issue for the volunteers as well, because I think the volunteers have to understand and have to have a level of comfort that they're not taking on a greater representation than what they've been trained in and what they are asked to do at that particular clinic. I don't know whether or not everyone on the panel has had an opportunity to look at the agreement, but I'm wondering if folks on the panel felt like that would be sufficient for their particular practices.
In fairness to the 86%, the agreement does say, I understand that Hudson Essex Legal Providers has agreed to represent me for the limited purpose. So it is an attorney-client relationship. It's just not a full scope attorney-client relationship.
Right.
It's one, there is still duty of confidentiality, there's duty of competence as to whatever you're doing, all the things that you would.
If they had signed this, so here's the other point. No one signed anything here. There was no retainer that was provided or document that was provided. And that's one of the main points of this hypothetical is it is important to have something in writing. And if you don't have a document, then there's issues of ambiguity. And I think that it's safe to say that issues of ambiguity are always going to be construed against the attorney. So it's important to keep that in mind. Okay? So let's go to question number 2. Hopefully I can get that up. And it's a bouncy one. Here we go. Okay. So are Annie and CPR obligated to represent Sammy on the eviction proceeding that resulted from the free application? So folks could vote now.
They're coming in quicker this time.
Yeah. People know where to look. Maybe I should work from here. Oh, right, I'm sorry.
Oh, I didn't know that.
Okay.
But how do you get it to?
Oh, but I don't know how am I gonna hit results?
I was leaving over to see.
I think you just green button it, and then it tallies, I think.
Okay, so we're up over 300 again. I don't want this to take too long, so I'll hit it here. And 80% say no, and 10% say yes. So I think it's true that that CPR is not obligated to represent Sammy on the eviction proceeding. The issue here is that they did not agree to work with Sammy with respect to this case, but this is one of the dangers of limited scope representation, is that you leave a client in a worse situation than they were before they had your limited scope representation. And so it is very important to be careful when you're taking on these. And in this area, like Bruce says, I don't want to scare people away from these opportunities, but it's very important that folks understand that what the information that they give you is what you're relying on. Now, no one would have advised Sammy about this situation necessarily. If he had come in with his papers, it may have indicated that his income, that his rent for the apartment was part of his income, and that would have been helpful if he had had it with him. The better court practice would have been here for help to have said to Sammy, we can't take you at today's clinic. We have a clinic next month. We'll put you down for that clinic, and that'll give us an opportunity to screen you and your application to make sure that this is the best route for you. And in this case, it wasn't.
But Lou,
Yes.
I would say that there's still a risk even after a screening. I mean, we've all had, no matter how comprehensive the screening is, it might not capture the correct information. The client may withhold information, may be confused. So there's still a risk, there's still some caveats, and it's important to make the client understand that what you're doing and how you're advising is based on the facts that the client has given you at the moment.
And that's exactly right. I designed this hypo to be something that wouldn't necessarily be something that Sammy was trying to hide. But there are times that clients may be trying to hide something, or they just don't understand the importance of it. But this was not one of those situations. I think Sammy was being straightforward with what he considered his income. He did not consider it as part of his income. But I think you do need to be very careful with respect to those. So, okay, the third question. Does the firm need to commence an action for wrongful termination? We won't spend a long time on this one. Okay. And again, overwhelmingly no, and I think that that is correct for the same reasons. There isn't a need to do that. It is not part of what you're obligated to take on. Now, morally, there may be reasons why you'd want to assist Sammy in this situation, but there isn't any obligation to do it. I think, though, that you might want to be careful even about taking it on morally, because he could later charge or allege that you might have that he wouldn't have been in this situation if you had done what you needed to do initially. So I think that it's important to keep that in mind. And then our final question is, was Annie's representation competent? If folks could vote on that. Okay, so while the votes are coming in, I'd love to ask the panel what their thoughts are about whether or not Annie's representation was competent.
If you forced me, I'd go with a maybe.
Okay.
'Cause I feel like we don't know enough about whether the conversation was lengthy enough, whether the right questions were asked. And it's sure not my area of law, so I don't even know what the standard questions would be that you would want to ask before doing a rent increase exemption, including do you pay rent, which Sammy doesn't, if I'm reading this properly.
Yeah.
So if the lawyer should have asked, do you pay rent, then perhaps it wasn't competent. Again, I don't know what she asked and what he answered.
Anyone else on the panel?
Well, you're assuming that she represented him, which in the earlier questions, there was the question about whether in fact she represented
Right.
him. So I think it depends whether somehow she went beyond just overseeing the filling out of a form and actually gave advice. And it's hard to know from the hypothetical which she did.
Right. Okay. So 57% feel that Annie was competent, and 32% fell into the category that Michael talked about, maybe, and 11% said no. The interesting thing about limited scope representations is, while there is no requirement to take on full representation, you do need to be competent, and the things that the court will consider are whether or not it's been made clear to the client that there was only this one area that they were going to focus on, what the volunteer's legal knowledge is, what their skill was, their thoroughness, and the preparation. And the hypo doesn't really go into a lot of that information. Was there a full training on this? Was there a lot of information that was given to Annie before she took on this project? And those are all the factors that need to be considered. I don't know that there's a right answer to this question. I put it out there for folks to kind of think about, because it's something that you should take into consideration when you consider doing a limited scope opportunity, is whether or not the folks that you're working with are going to be providing you with training. Are they going to be preparing you to handle every situation or most likely situations? Is there going to be someone from the legal service provider in the room to assist you if you have any questions? Is there a document that talks about with the client that this is for a very limited scope? And I think those are issues that you should be considering when you agree to take on this type of a clinical opportunity. So,
There's two questions, which I'm just going to paraphrase. One, which sort of gets at the issue that Janet was talking about, is you might take the view that there's not even a representation. All you're doing is giving some information and helping someone fill out a form. But the question, which is a little skeptical, is given what you're doing, isn't the client can at least think that it may be a limited scope, but that there's a legal representation? And the other question, which is similar, is doesn't this turn on what the client thinks? Or reasonably thinks, I suppose, would be the standard, right? So if the client reasonably believes that you're representing them and not just holding an educational seminar or acting as a scribe or something, then if you don't disabuse them of that reasonable belief, it seems to me that the pretty fair argument that they're limited scope clients. Right?
yeah, and I do think that that's important, is what a reasonable client would expect.
I think embedded in this hypothetical is another interesting question, which we haven't really talked about yet, which is who, if you're going to enter into a limited scope representation, or when you're talking about who is either entering into a relationship with the client, who's the lawyer? Is the lawyer the pro bono lawyer, or is the lawyer the not-for-profit legal services office, or is it a combination of the two? And I think that it raises just a broader question generally, that when you're doing pro bono work, it's really important to know the answer to that. Are you doing work in your own name that you've been given by a law firm, or are you working collaboratively with the not-for-profit? And if you are working collaboratively, is there someone who's lead counsel? Is the form on the letterhead of the legal services office, or is it on your own personal letterhead? And you would want to work out these things. I mean, in this kind of very limited setting, it really goes to the issue of, are you acting individually, or are you acting on behalf of the legal services office? But certainly in pro bono representation, where you're taking on the role of being counsel with a legal services or other not-for-profit organization and doing a big case that lasts for a long period of time, There are questions about who's lead counsel, who gets to define the direction of the litigation, how do you define what the settlement terms look like? You know, which of the lawyers has that role? And I think it's important to work all those things out.
I thought you were going to raise something different, which this also raises, interestingly, which I think is really an issue for Jennifer. So let's suppose CPR, which is a law firm, has a pro bono program, and it sends its associates out to do this limited thing, you know, Monday Night Law, whatever it is. Is the associate, assuming there's a limited scope representation, is the associate the only one representing this individual, or is the firm also? Because the whole point of 6.5 with limited scope representation is you avoid conflicting out the firm, which implies to me that the lawyer is doing it sort of in an individual capacity and not on behalf of the firm. But if you go and say, this is CPR's, you know, pro bono night at the Bar Association or whatever, and we're sending our associates out, I'm not sure 6.5 works anymore, because it sure begins to look like the firm as well as the individual associate doing the representation.
I don't read 6.5 to say that a firm can't participate in these limited scope clinics. I read it as specifically saying a firm can, and that 1.110 imputations of conflicts is not going to apply. Because even in Rule 6.5, if you as the lawyer meet a client and have actual knowledge of a conflict, you can't continue speaking to the client in the clinic. What 6.5 lets you do is go meet the client, and I work at a 1,000-person law firm. I haven't run the clinic client's name through my conflict database. I can't possibly know what everyone else in my firm is doing, and that's okay as long as you meet the requirements of 6.5. I think if you're a solo practitioner, you almost wouldn't even need 6.5 because you would have actual knowledge pretty much of what you do in your own mind. And so, I mean, certainly at Cleary, we take the position that when we send our lawyers to legal aid's clinic, it's Cleary Gottlieb participating, but we don't have to run conflicts in the same way that we normally would because we're in the safe harbor of Rule 6.5. But I tell every lawyer before they go that if they go and they are aware of their own conflict, they need to stop speaking with that client. That's part of the orientation that I feel we have a responsibility to do as the firm piece of it, in addition to what else legal aid is doing.
So we have no more questions on this segment. I don't know if there are any. Yes, sir.
The word competence in that matter. So where I work, we have clinics that are open all the time. You have people coming in, asking them to help fill out forms. Can you tell me what this says? I'm having problems with Con Ed. Can you tell me what my options are? So is the competence like competently filling out a form, or competently telling them who they should call, or actually being able to foresee consequences?
Right, and I think that is one of the challenges
You should
of
repeat the
doing it.
question.
Oh, I'm sorry. The question is when defining competence, what does that mean? Does it mean taking on responsibility for knowing what's happening in a particular area of law, or are you competent in filling out this form, or are you competent in advising them what the risks are? And I think it is one of the challenges of doing this type of work. I think that helplines and hotlines often have these type of issues come up because you are giving advice and you're trying to give the client the best advice that you can, but you are doing it with limited knowledge of what their situation is. And I think that's more where the danger is. I don't think it is competent for you to assist somebody in an area that you don't have any knowledge in. I think if you're going to read a document for someone that is in an area that you're not familiar with and give them advice based on your reading of it, that I think is you're putting yourself at risk. I think that you would want to be trained in a particular area. I think you'd want the call or the walk-in client to be in a particular focused area. And I think with respect to volunteers, you certainly want to tap the resources of the folks who are sponsoring that clinic before you give advice in an area that you've not had, has not been part of your training or is not part of the call-in center's focus, because you are putting yourself, and I think you're putting the provider at risk by doing that.
Okay, so why don't we turn to Jennifer's hypothetical, which is at page 255?
So my hypothetical sort of picks up where Lou's left off, in that you are at one of these clinics, and now you've come back to work the next day, and a partner approaches you and asks you to work on a project for a new client, and that new client, prospective paying client, is the landlord of the person you had seen last night at the clinic. So can you represent that landlord who is a prospective paying client of the firm? And as I mentioned, what Rule 6.5 does that I think is important for people who work at larger organizations is it allows you not to run the names of the people you're going to see at the clinic prior to going to the clinic. And I think my hypothetical raises the question of what happens after the clinic. Should you be going back to your firm and running through the names of all the people that you've seen? And the answer is interesting, I think, because the New York State Bar Association ethics opinion just this past July addressed this issue. It's opinion 1012, which you have in the materials, and they say the lawyer cannot represent the landlord unless he gets informed written consent from the client that he had seen at the clinic. I think that's not that surprising, because the whole purpose of Rule 6.5 was to obviate the need to sort of run conflicts through the clinics. What I think is more interesting in the opinion is the next question. Assume that you were not the lawyer asked to work on the project. Can other lawyers at your firm work on it? And the answer to that is yes. It is sort of an exception, again, to the imputation of conflicts that typically exist. And I think that also makes sense when you step back and think about it, because you don't have all the names of the people you've seen at the clinic. And in my example, you went, on Tuesday, and on Wednesday, the landlord shows up. But in real life, it might be a year later, 2 years later, 3 years later. So you can go to a clinic as long as it meets the requirements of 6.5. You don't have to worry about running conflicts before. You don't have to worry about feeding the names in after. But you do have to be mindful of what you know. And so you can neither represent the client at the clinic or speak to the client at the clinic if you already knew you represented the landlord, nor can you come back and pick up the project for the landlord. So we touched on this earlier. Can you call Ms. S., who's the person you saw at the clinic, and tell her, hey, look, the landlord may be selling your building. So I know that you were thinking about organizing or thinking about doing different things because the landlord hasn't been providing the services. You may want to change your tact because I have reason to believe that the landlord is going to sell. And the answer to that, I think, pretty clearly is no, you cannot. Even if your firm decides not to take on the landlord as a client for reasons having nothing to do with you and your little clinic that you did, you do owe duties of confidentiality even to prospective clients. So you need to be careful when people come in and speak to you pro bono or paying about the possibility of taking on a legal matter. You do owe duties to those people and have to protect the confidentiality of what they tell you. And can you tell the landlord that the tenants might be organizing? After all, just the day before you told the tenants that they should organize. So, and also, unsurprisingly, the answer to that is no. I think the duty of confidentiality clearly exists to the people you speak with at the client, even though it's just limited scope legal representation. And you may not have a duty to continue on in Lou's hypo or in my hypo, but you still have a duty of confidentiality to the clients. So I don't think that's that controversial, but.
Can I ask a question? What are the implications, because I don't think the bar opinion deals with this question, for conflict checking? Do you input, or would one input into the firm conflict checking database the pro bono representations, or you just leave it to
When we
chance?
take on full pro bono representation, we follow the exact same conflict checking process that we would follow if we take on a paying client. For the limited scope Rule 6.5 clients, we don't, because the rule lets us not. And we really would have a problem going to the clinic if we had to, because our conflict checking procedures are somewhat cumbersome, and they're not designed to let you instantaneously know if there's a conflict. And at most of the clinics, at least that I've been to, even when they're scheduled appointments, people show up and there's a lot of no-shows. And so we don't run those names through before, and we don't run them through when we get back to sort of put them in the.
To me, I mean, that's consistent with the whole point of this is if you had to do all the conflict checking, you would spend all your time dealing with conflicts and you never represent the clients. And so it's a pragmatic rule that recognizes in part that the representations are short, not a lot of confidences are imparted, but most importantly, we want to encourage pro bono, and you can't do it with, half-hour representations that have 3 hour of conflict
Right,
stuff.
or more. I mean, an hour in most firms that I know of in the conflicts check, we run the names through our record of all the clients we've ever represented, and the names go out to all of the partners worldwide, and we have to give people a chance to look at it and say if there's a conflict. So it's, quite a whole system. But I do want to emphasize, so that no one leaves with any misunderstanding, that Rule 6.5 only operates in certain contained circumstances. And if you're not within the safe harbor, if you will, of Rule 6.5, you absolutely have to run conflicts the same way you run it for a paying client. And the fact that you're not getting paid and the client is pro bono is no excuse not to run conflicts. So it's really a narrow exception, and it has to be a program. The states vary, but in New York, it has to be a program that's sponsored by the court or, I think, a government entity or legal services provider. And so Cleary Gottlieb itself can't decide, well, we're going to open our doors and have people come in for limited consultations and we don't have to run conflicts, because then we're not in the safe harbor of 6.5. So if you're meeting a prospective client, a one-off prospective client, you're not in the safe harbor of Rule 6.5. You're just deciding if you're going to take a client. And I think that's important to stress.
Jennifer, I know that many of the firms represent governments or cities or counties. When that issue comes up, how do the firms handle that?
I mean, I think I'm going to give the lawyer non-answer. It's an individualized assessment of whether conflicts exist, and that's the truth. And that's the same thing. We do a lot of sovereign work as well as a firm, so we represent a lot of countries, and it really is an individual look at whether this particular matter is going to be adverse to an existing client or to a former client. And the rules for that vary as well.
What about waivers? Are there ever waivers, general waivers or specific waivers for particular?
I mean, firms use waivers all the time, right? In the paying practice, 1 week you're sitting across from an investment bank and representing them, and the next week they're on the other side of the deal. And so I think waivers can work, and they are used all the time. How willing a firm is to use a waiver in the pro bono context, I think, depends on what the representation is and whether you want to go to the client and ask for a waiver. I would be particularly nervous asking a pro bono client for a waiver because I feel that they will often not understand what you're really asking for and maybe feel almost bullied into giving the waiver because you're representing them for free. So we haven't had that situation where someone has come to me and said, oh, you represented or representing so-and-so pro bono, we need a waiver to do this paying work. But I would feel that that's something that would need very serious thought before. I find my pro bono clients will sign just about anything. No matter how many times I say, no, don't sign it without reading it. No, you have to ask questions. They're happy to just sign whatever I put in front of them. They trust us, which is a good thing, but also can be a bad thing, depending on what you're asking them to sign.
This government issue that you raised, Lou, is very complicated, so I would agree with Jennifer.
My
that-
non-answer.
But just on the waiver point, for example, so now if a law firm wants to do pro bono work with my current employer, the New York State Attorney General's office, what does that mean? Does it mean that they can have no representation in front of the office? Does it mean that they would need a waiver? Would they be representing the agency that the Attorney General's office is representing in a defensive capacity? Would they be representing the people of the state of New York, in which case, how do you get a waiver? So it's quite complex. Interesting, but complex. Yeah.
Okay, so moving on to B. The next time you go to the clinic, because you liked it so much the first time, you meet with a different client, Ms. T, and she is facing eviction because her husband was forced to leave the apartment after a domestic violence incident, and Ms. T is not a tenant of record. She's filed for divorce pro se and is representing herself pro se in the eviction proceedings. You really like her, and at the end of the clinic, you tell her you would like to represent her in her eviction case. You've never done it, but you figure it can't be that hard. Can and should you represent Ms. T in housing court? And I think this goes right to the competence issue. Rule 1.1 discusses competence. You have to be competent. You have to be able to provide the legal skill, knowledge, thoroughness, and preparation reasonably necessary for the representation. I think 1.1b says if you don't have the competence, you can associate with someone who does. And I think that's really critical for pro bono representation because what Bruce started with, which is we don't want to scare people from pro bono, is true. Just because you haven't done it before doesn't mean you can't do it. And in housing court, where 95% conservatively of the tenants don't have counsel and 95% conservatively of the landlords do, we don't want to say, well, you've never done it, so don't do it, and let's just leave things the way they are. But what you want to ask yourself is there anyone in my firm who's competent to help me with this? And maybe more importantly, is there anyone outside my firm, maybe the nonprofit that sponsored the clinic, who's competent to help me? And are they willing to work with me? And how are they willing to work with me? Are they willing to review the papers? Are they willing to come with me to court? Are they going to co-counsel? Or are they going to mentor me? And so when we take a matter at Cleary, we really try to have both a senior lawyer with expertise in that particular subject matter, and we almost always, I'd say 90% of the time, unless it's something that we have a very high volume of, but we almost always associate with a nonprofit provider who can mentor us at a minimum and co-counsel if it's something we don't do a lot of. Do you have to tell Ms. T that it's your first case in housing court? So I think you don't. I think you need to be careful, which goes into the next one. What do you say if she says, how many cases have you won? So I think,
I've never lost.
Right. I think that was exactly what I was going to say. I think Maybe you don't have to say, and by the way, it's the first case I've ever done, but if she says, how many cases have you won? And you say, I've never lost a case in my entire career, you know, that might be bordering on, or not even bordering, that might be crossing into being misleading. And obviously you have a duty to be honest with your clients. I think it's an interesting issue, how much you have to tell clients, period, whether it's pro bono or otherwise, about how much experience you have in a particular area. Unlike when I used to do beauty contests for the commercial litigation, and the clients, were very sophisticated, and they wouldn't just ask, have you ever done this kind of case? They would say, give a list of every kind of case and who's going to be on my team and how many of those cases have they done and what jurisdictions were they in. I've been in this role 3.5 years. I've never had a client ask me if I've done something before. They just seem to be happy to have someone willing to take the case and willing to work with them. And that's at least been my experience. Very rarely, and how many cases have you won? Phrased slightly differently, more like, do you think I'm going to win, or do you think you can help me? Yes. But specifically, have you done this kind of asylum case for a client from Uzbekistan? No. So I don't know if you think, and you have a duty to tell a client that
I
you
think
haven't
you
done?
don't. When the bar gives you that license, it basically tells the world something that's probably not true, which is that you're qualified to do anything with mentoring and study and a little bit of help.
Yeah, I rarely have. Occasionally they stand out in questions when the client asks that question of you, and I kind of be honest with them. I say, I do fudge. I can fudge, but also I say, I could be lying to you. I could, do you know if I tell you I've won 25 cases? I mean, are you going to go bar and look up, the file? Or, and unfortunately, in the legal profession, also you can't give references. And people say, I've had clients ask me, well, can I speak to some of your clients and, who you represented or whatever? And I go, I can't tell you that. Just like, you don't want me telling anyone about your case. I can't tell you who. I can't give you some phone numbers like a contractor and say, call that lady and you can see what a wonderful case I did for her. And you can't do it. So.
Well, and I mean, I guess because I did litigation, you would appear on the paper, so everyone knew, it wasn't a secret that you represented so-and-so bank in this litigation, because that was public, so there was nothing secret, but you're right, I never thought
Well, it's
about
usually
that.
word of mouth. I mean, hopefully,
Yeah.
most of my business comes word of mouth.
So people have-
They're not looking up an ad in the yellow pages and saying,
Right.
They're asking for references. They say, well, I've heard your name from 2 places, your name's on a list, this hospital or whatever, and that is usually enough, and they're just, thrilled to come in, and like you said, just listen to what you have to say.
Right.
They're not questioning at that point. So,
Yeah, I think that's true. When I was a public defender in arraignments, a client one time came in and said, I'm strung out, I need to go to jail because I need to get down from this, I can't go in. And I said, you want to go to jail? And he said, yes. I said, I'm your guy. That I can do.
can only go up from there, right? Right? You keep him out, he's like your God.
Okay, so moving on. The first thing you need to do is to get Ms. T on the lease, and Mr. T needs to do that. Mr. T is a reference to the A-team, for those of you. Ms. T tells you that her husband is represented by counsel in the criminal case that stemmed from the domestic violence incident that got him thrown out of the apartment, but she is not sure if he's represented by counsel in the divorce case. So can you call Ms. T's husband? This moves into the rules of communicating with parties that you know to be represented by counsel or have reason to believe are represented by counsel. And I think here, the husband is represented by counsel in the criminal case. You're not sure in the divorce case. I think you should assume that the husband is represented by counsel. Even though, in all likelihood, criminal law, it's a little bit of a fault of the hypothetical, because it's very unlikely that the criminal lawyer is the same one handling the divorce. At the same time, the same issues in the criminal case here, domestic violence, are likely to be at issue in the divorce case because of the grounds for divorce and if they have custody. And I included a New York State Bar opinion, which is somewhat similar, where the municipality's lawyer knew that a pro se litigant was represented by counsel in a criminal case, but in that hypo, or in that opinion, since the case was filed pro se, the civil case, he kind of knew he didn't have counsel, and even there, the bar sort of said, slow down, don't reach out and talk directly to the client. So I think the better course of action here would be to assume that the husband has a lawyer and to reach out to the lawyer and not directly to the husband. Can Ms. T call her husband? So you decide you're not going to call the lawyer, or maybe you try and you can't reach him at first, and Ms. T says, well, maybe I should call my husband and ask him. Is that okay? And if it's okay, can you tell her what she should say? So I would be remiss in not saying that in a domestic violence case, I think the first thing you need to do is think about whether that's really a good idea anyway. And a lawyer, under the ethical rules, is not just a lawyer, but is also a counselor and should be thinking about those things. And so it may not be the best practice, the way you might in another kind of case, to say, sure, call your husband who beat you up and tell him to put you on the lease, because that might start down a very complicated cycle of abuse, especially if they hadn't been talking. But if you leave that aside, she can call her husband, but you need to advise the lawyer that she'll be calling. So you don't have to ask his permission the way you would if you were going to call him. You just have to give reasonable notice. And I think that's if you're talking to your client. So if your client went and called her husband without you knowing about it, you don't need to do anything. But if you are having the conversation and you're preparing a script or telling her what to say, then Rule 4.2b requires that you give reasonable notice to the lawyer. And I think that's to give the lawyer a chance to do what you're doing, to say, okay, she's going to call, here's what you should say back.
So we should say, since the audience includes not just New York
Right.
lawyers, but, lawyers from the other jurisdictions, that what you just described, Jennifer, is a unique New York rule.
Right.
And if you're outside New York, there's no 4.2b that talks about giving notice to the other lawyer. There's an ABA opinion on this that says, in general, you could counsel your client because the client's not herself bound by the ethics rules. You could counsel the client to go communicate with the counterparty, and the only limit is you can't so script the communication that they're basically your sock puppet, that you're manipulating them. But otherwise, you can advise them that they ought to do the communication, or if they ask you, you can tell them they can, and you can counsel them about how to do it. And so here's one of the areas where it's important to consult your own jurisdiction's rules, and it's probably a good time to say where, in general, talking about ethics rules in general, we all have a New York bias, and so I'm sure there's some disclaimer in the book. We're not giving legal advice. Don't sue us if it doesn't apply to you, and check your own rules and your jurisdiction's ethics opinions.
If it wasn't in the book, it's covered now.
So you email and call Mr. T's criminal attorney and he never calls you back. What should you do? I mean, this is very common, I think, because he's thinking, why is this person calling me? I don't represent him in the divorce, or he's just really busy and in court all day, or who knows why. At a certain point, you can assume that he's unrepresented. I think it would be different, and at what point you can make that assumption would vary if this was a litigation where the lawyer had appeared, for example. And so there's a court filing that says, Doug is the counsel of record for Mr. T. He doesn't call me back in 24 hours. I can't go call his client.
And you're assuming that he's handling a divorce and he's in housing court? And that's why you're calling in with housing court? Let's get her on the lease, let's handle her divorce? Isn't the fact that he's a criminal lawyer, doesn't that establish that he does not have the competence? That he would be getting himself into some sort of an
Just
ethical
because he doesn't have,
dispute?
well, repeat the question. Just because he doesn't have competence, he doesn't, is not saying, give me some money and I'll do it for you.
The question for folks at home is, he's a criminal lawyer. You're asking him about a matrimonial and you're asking him about housing. Isn't the fact that he's a criminal lawyer enough for you to indicate that for there to be an indication that he is not competent? And I think it depends, because I think in New York, again, and we are New York centric here, but that is true. People do tend to specialize, but I think there are areas, even
Lots
in
of
New York,
areas.
where folks do all of those things and practice in many of those areas as a general practitioner. And certainly divorce and criminal is an area where many folks practice in both. Whether or not housing is part of that, it's hard to say. But I do think it would be hard to assume, just because he's representing him on a criminal matter, that he wouldn't also take a divorce matter.
In the integrated domestic violence part, where I often work,
Right.
Often people will have the same criminal lawyer that they have on either a matrimonial or a family case. Not that it's necessarily a good idea, but it does happen.
So if he has a lawyer in anything, if he has a housing lawyer, and you've got a domestic issue, you should just assume that it's worth making the phone call, wait until
You have to
you
exclude him.
get, right?
You have to presumptively try to exclude him, I think,
Right.
right? That's all.
And if you don't hear back after a couple of attempts, you can sort of move on to reconsidering whether he's represented.
If you made a mistake and you didn't assume it, and you called him directly, and it was in the IDV court, and he did represent him, then you would have breached your ethical obligations. If you call, 3 times and he never calls you back, I think not calling back 3 times plus the fact that he's a criminal lawyer would reasonably let you conclude that he doesn't represent him, and then you make the call. And so it's a question, I think, in ethics often, of taking the course of action that's going to be the safest course to make sure not you particular, but to make sure you comply. To make sure that you're in compliance with that.
This is somewhere where it really matters what jurisdiction you're in,
Yeah.
in a couple of respects. So first of all, the rule says you can't communicate with somebody you know to be represented in the matter, and knowledge is a defined term in the rules, and so you'd think it means actual knowledge, and nobody's come and, from the sky and told you, and so maybe you could pretend you don't know. But in New York, at least, the opinions put some burden on you if you have reason to believe the person's represented to ask the question. The other thing is you can't communicate with someone you know to be represented in the matter, and the question is, what does that mean? And so in some jurisdictions, even if you're only represented in the criminal matter, because this other case has implications for the criminal matter, because the client might say things that are really stupid that can come back to bite him in the criminal matter, that puts the client off limits even in the housing court, for example. And in other jurisdictions, they read matter narrowly, and so they say, well, he's representing the criminal case, but you want to talk to him about a housing case, even though there's some subject matter overlap. It's not the same matter, go ahead and do it, and you go around the lawyer's back. So this particular rule, 4.2, is one where you probably have more different interpretations by more different ethics opinions and courts than any other rule.
We have one question here first. Sir?
Can't you largely resolve the issue by simply sending an email in which you add specifically, I'm representing so-and-so in connection with this. I understand you are representing someone else in connection with a different matter. Are you also representing that person here?
So the question is can you avoid this situation by sending an email indicating what your role is now, and that you're aware that the person represents, the lawyer represents them on a different matter. Are you also involved in this matter?
Yeah, and I think that's exactly what you would do. You would email and maybe follow it up with a telephone call in case.
The criminal lawyer is not representing the husband in either of the other two cases, but the husband assumes that he is, because that very often happens. And so you have.
I think the question is what if the criminal lawyer is not representing the husband in the other two matters, but the husband assumes that? I think if he does assume that and you reach out to him, you would hope that he would say to you, I have counsel. And if he doesn't say that, then again, I think you can have the answer. You can have the discussion with him. We're getting tight on time, and we have two more
So I'm gonna move
hypotheticals.
fast.
Very fast.
You call Mr. T and ask whether he would be willing to ask him to the lease. He clearly doesn't understand who you're representing, and he says, I'm so glad the court appointed you to help us resolve this. This is not that uncommon. Now I'm self-conscious because I'm afraid I'm talking about people I'm not supposed to be talking about. I think here you have an obligation to correct that misrepresentation, clearly. There's not going to be any debate on that. I just want to mention two more things, and since we're tight on time, I'll do it outside of the hypo, but I get a million, not a million, that's an overstatement, but I get many, many, many unsolicited requests for help every day. And Bruce touched on this. People send me documents all the time, and the question is, do I have to respond to all of them, and should I respond to say, I can't represent you? So there is a New York State, at least a New York State ethics opinion that says that there's no duty to respond to unsolicited. In that opinion, it was in prisoner mail. So I get a lot of mail from prison. You don't have to write back and say, I don't represent you. And while I would like to refer everyone who contacts me to counsel, I think there is a danger in engaging with people who haven't, a lot, you can tell from a lot of the letters that I'm not the only person they're writing to, and I think you do want to be careful if you're going to start engaging with a dialogue. Oh, you have this kind of problem, maybe you want to go here, that the person might misunderstand whether you're taking the case or not. And so respond. But certainly, going back to the original client that you saw, if in loose hypo, the person thought you were going to, you see someone at a clinic and they thought you were doing something because they didn't understand the informed consent that you had them sign, then that's a different situation because the person was your client and you can't just ignore them and hope that they go away. You have to go back and say, I was only helping you do X, Y, and Z, and I'm not helping you do these other things, and I suggest you try to find counsel, and here's where you might be able to look for counsel.
Okay. Michael, I believe you're next.
Good morning. The three questions that I'll be talking about all relate to a hypothetical custody proceeding and a relocation proceeding. You can all hear me, right? So in the first one, the issue is client misconduct. Just as a preliminary, it'll be Rule 3.3 we'll talk about mostly in this first one. In this first example, you represent the mother. There's a prior custody proceeding that was settled, and it required the parties to live in one particular area, and you represent the mom who's seeking to move to an entirely different state. So you help her file a petition. You as the attorney help her file a petition, and then after that's filed with the court, after it's sworn and filed with the court, and asks you to that they might get away with the having moved before coming to the court, and no one will know. Neither the father's lawyer, nor the child's lawyer will find out. At least your client thinks so for the purposes of the hypothetical. So the first question is, can you do something? And the related question is, must you do something? And the last question will be, what happens if you didn't find out till the case was over? So first, can you do something? Let me preface this by saying, at least the way I read it, I've come to the conclusion that you must do something. So maybe it's easiest to go straight to your 3.3 duties of candor to the court. I'm hoping someone on the panel might disagree with me. But let me first set it out, at least the way I've framed it, it is a pleading with the court. It's sworn. And there is an issue about whether that's evidence for the purposes of Rule 3.3. And 3.3, if you want to look at the exact words, on page 130 of your text. And I should have told you earlier, my hypo is on page 327, just in case you wanted to flip back and forth in that book. You can get that binding nice and worn in. So first, the issue of whether it's evidence under 3.3. In your materials on page 333, there's a Connecticut ethics opinion from 1999 that comes to the conclusion that if it's something that was submitted to the court in connection with a pleading or a hearing, that it is evidence for those purposes. So assuming that we follow the same logic that the Connecticut ethics folks followed, we would have to conclude that this is evidence before the court. And I included a couple opinions from New York that come to different results, although different facts too. On page 339, there's a New York opinion from 2013 about a false statement in a sex offender registry, whether you have a Rule 3.3 duty there. That's different because you're not before a tribunal, and it was an application, it wasn't a document filed. That's on page 339. Another contrast is sort of an interesting one, New York State Opinion 945 from 2012. That's on page 345. There, the opposing party is reading the other person's lawyer-client emails. That's in the context of a matrimonial. So on the first two portions, whether you can and whether you must, at least under these facts, you can't be the proponent. You can't be representing the proponent of a petition that you know has a sworn misstatement, and it's made even easier because you help the person prepare the petition. Perhaps different if they prepared it on their own. Although even then, if you follow the Connecticut logic there, you're stuck in your role of being basically enforcer against your client. I don't know if anyone wanted to.
Isn't the issue that it has to be a material fact? Which
Yeah,
arguably
which
this would be.
by definition, since the whole matter before the court is whether to grant a relocation or not,
Right.
then yeah, it's definitively material.
Right.
Yeah.
What if you advised her to move back to California and call that little sojourn a vacation? Would that solve the problem?
Extended.
Yeah, good question, Bruce. I would say no. It doesn't solve the problem because there's still this falsity there. And the other thing is, I don't know if you winked when you said it, because I mean, I think it's easy in these contexts for a client to misinterpret that advice, right? Because there's still the lie was out there, and what I'm trying to get at in a less articulate way is telling them to consider construing that as a sojourn rather than a move smacks of you telling your client to lie to the tribunal, which that's a clear no-no. That's an easier one to know is wrong.
But I think if you said you have to move back, and if you move back before we're in court so that you've now made this representation accurate, and you move back and you have to have the intent to stay where you are, and you put your child back in the school in the state, the state of origin.
Yeah, I chose a 2-year-old so the child wouldn't be in school.
Right.
I still don't like it, Janet, but I get it. I mean, I think the lie's still out there. It was a lie when it was sworn to. It was a lie when it was sworn to and you helped the person swear to it. Whether they then have to file an amended petition with the right date on it, I think you're still in a bad jam. Your client's put you in a bad position. And your client's asking the court to ratify something that your client's already done, that they shouldn't have done without court permission. So
I
they've
mean,
violated the
my-
original
My
court order.
advice, I think, to the client would be to move back and then indicate to the court that there was some confusion about what my client's roles and was to be, or what her responsibility was. I've advised her that this would be perpetrating a fraud on the court. She's moved back in anticipation of the court's ruling and put it out there that the client had made the mistake, or made a mistake, so that, because if it comes up later on, and it is likely to come up later on, and you haven't disclosed that, then it's going to look as if you were hiding it.
I mean, perhaps my frame of reference is I'm usually representing people with limited means.
Right.
So moving back and forth over hundreds or thousands of miles isn't always in the, it's not on the menu of options necessarily.
Right.
I still think, I mean, at least the practical advice, I still think you have to tell the court, oops, this was wrong, and file a new petition saying, admitting the violation. But I hear you, if you could move back, perhaps. I still think, we've
Well,
got this sworn
so-
document out there.
So you're talking about how you go about correcting the record. I think there's still a role for advocacy in how you correct the record. Do you say, oh, I committed fraud in this
Of course, you
initial?
wouldn't- of course you wouldn't use that word.
Right, right, but you might file a revised petition correcting it without pointing out all the problems about what the client had done.
You might even say something like, although the father doesn't know this because he hasn't seen the kid in I don't know how long, I'm coming forward and,
Right, exactly.
sort of pitching it
Yeah.
in a way that would be beneficial to your client.
Yeah. Interesting take on it. I was hoping one of you might say that 3.3 somehow didn't apply. I kind of have a profound distaste for 3.3, although I understand its purpose.
But I do think this is also one of those situations where you do have to look carefully at your state's rules. Because although it's mandatory in New York, in other states, not only might it not be mandatory, but you might not be able to disclose.
Which is the good segue, perhaps, into the
I think
third
California might be one
That may be,
where-
but we were one of the last holdouts to change our rule. We
And
used to say
California has a
confidentiality
different-
trumps. Yeah, it's a big state, so I guess it's important to check.
I'm just wondering, it sounds like there's also another issue that raises is how do you get out of a client like who lies to you? Because if they lie to you about something that is that material, how do you trust them going forward? I mean, you're really in trouble thereafter.
Yes, you are. I mean, by definition, this is a difficult client. They came to you after they did something instead of before. Although before they might not have liked the lawyerly advice, because the lawyerly advice would have been wait for a judge to rule on your petition, right? Because that's the proper legal advice. You shouldn't move across state lines in violation of a court order.
I guess what I'm talking about is specifically, you're sitting there with your client and you're writing this out, and your client is saying, yes, I live there, I want to live there, but they really already have moved. So, I mean, they're lying to you, and, I mean, to me, that's a very tough situation. How do you get out of that and still say to the court, or I would want to get out of that representation, but then how do you get out of that representation and not, put your client at rest? I don't know, maybe it's a different hypothetical.
No, it's a different one, but it's a very good, I'm glad you raised the issue, because your client has lied to you, has kind of not induced it, but has gotten you to prepare a paper for them that was a lie, and they even, in the fact pattern, they even went to some length to elaborate on the lie about what their plans were, how they were going to move. So depending, you might have a basis to withdraw from the case, yes.
But I think you would really have to explore it with the client. I mean, you would have to have a very honest, frank conversation with the client. You'd have to figure out whether this misrepresentation went to the core of your relationship and whether you could continue to represent the person, whether there was a basis for moving forward. I mean, one of the things that happens a lot in any case is that clients advocate for themselves in ways that mean that they don't always act in a forthcoming manner with their lawyer. Sometimes it takes a long time. It might be well into the representation before they're ready to trust their lawyer with all of the facts surrounding their case. And I think that a lot of times when when lawyers engage in pro bono matters, you have this idea that your client is, you're finally getting this opportunity to do good, and your client is perfect, and it's just going to be straightforward, and people are complex. And, it may be that it's still an absolutely valid application to allow this mom to move to another state, and the fact that she jumped the gun could be for a whole lot of reasons, and her own manner of coping. And I don't think that we as the lawyer should assume that this means that everything that we're being told is a lie and that there's a true breakdown in the attorney-client relationship. I think it has to be explored.
Question in the back, I'm
Okay.
sorry.
No, I was just, we have a ton of stuff to cover.
Yeah.
So let me go on to
Whatever.
if the proceeding concluded, can I go on to that one? So there, New York's rule differs from the ABA model rule. New York's rule actually doesn't say, that is silent on, or actually New York didn't adopt Rule 3.3C. So in New York, well, I'm sorry, outside of New York, Rule 3.3 is on page right, okay, sorry. 3.3C I don't think we have in the materials. But ABA model Rule 3.3C specifies that the duties in 3.3A and B end at the conclusion of the proceeding, which makes a world of sense. For New York, that's not, C wasn't included, but there are some ethics opinions that aren't in the materials that come to a similar conclusion. And there's a New York City Bar opinion, 2013-2, that you only have a 3.3 duty if there's some remedial measure that would work. So if it's the conclusion, if the proceeding is already concluded and there's no remedial measure, then your 3.3 duty isn't there. There are also two New York State Bar opinions, also not in the materials. Ethics Opinion 837 from 2010 and Ethics Opinion 982 from 2013. Any questions on conclusion?
So let's zip through the other two
Excellent.
parts of your.
Okay. So unauthorized practice of law. So this is Rule 5.5, which is on page 167 of your materials. And here, you've switched, now you're the attorney for the father. The attorneys don't get a very good, it's a bummer for both attorneys in this situation, right? The first attorney gets the lying client. The second attorney gets stuck trying to negotiate out of state with someone not admitted in the jurisdiction. So in this hypothetical, it's the person who relocated retained a lawyer in their new state, and the proceedings are all in their old state for the purposes of the problem. It's Texas and California. So the Rule 5.5A of the model rules, 5.5B of the New York rules, you can't provide aid to the Texas lawyer since that lawyer is not authorized to practice law in California. So the real issue is whether there's a reasonableness of how long the lawyer is waiting to seek pro hoc vice admission in California. And under the facts I gave you, I chose 6 months, hoping that the audience would think 6 months was unreasonable, since a pro hoc vice admission is a fairly pro forma thing. So if you've sat on it for that long, it seems to indicate that you're not being reasonable. So the conclusion I was looking for was that it wasn't reasonable for that lawyer to be practicing out of state, and it would be unauthorized practice. So the question was, is it proper for you to negotiate a potential settlement with the out-of-state lawyer? And under either one of the 5.5s, the New York one or the model rules one, it's aid to an unadmitted lawyer in your jurisdiction. So it would be a 5.5 violation. So the issue there is, what can you do if you're negotiating with this person, with this party who's retained, using the word retained loosely perhaps, retained someone who can't practice in your jurisdiction? And I can give you a couple opinions. Sorry, I didn't mention them. Page 351 has an Ohio advisory opinion, and that's relating to consumer debt settlement and debt negotiation, where the out-of-state lawyers can't practice in Ohio. On 359, there's a New York opinion, 835 from 2009, about a general counsel. And two more from Texas there. page 363 and page 369 about what out-of-state lawyers can do, and Texas has adopted the, what's it referred to, the multi-state practice? What's
Multi-jurisdictional practice
Thank you.
Yeah.
Multi-jurisdictional practice. So those are 363 and 369 in your materials. So practically, what can you do if you're stuck in this situation? And my proposal was that you give notice to the other side that you deem them to be not represented. And absent some pro hac vice motion or some other action on the other side's part, you either will negotiate with them, you'll either contact them directly or you just won't negotiate with them, which is always a possibility. I don't know if anyone else had a different.
In your hypothetical, has the lawyer, the out-of-state lawyer, had an opportunity to appear in court and to seek pro hac vice admission?
6 months of proceedings.
And
where
the court
they've asked for
hasn't
adjournments.
complained? If the court doesn't care, what do you care?
That's my,
Oh, but 5.5 sticks you, right? You can't aid an unauthorized
I
practice.
don't know if you're aiding. You're representing your client before a tribunal where the judge is indifferent to the pro hac vice rule. To me, that's between the judge and the other lawyer. You could raise it in court, but I don't know that you could boycott that lawyer or go around the lawyer's back.
So you don't
under
interpret
4.5.
5.5 as that providing aid to the unauthorized practice?
I'm not sure it is. I don't
Right.
think you're aiding them. You're just negotiating with them. You're aiding your client.
I agree
Well, you
with
are permitting
Bruce.
them, you are enabling them to practice out of state.
But it puts an incredible burden on the lawyer to figure out the status of the lawyer in another
Oh.
jurisdiction. What's the status of the application? Is the pro hac vice application pending but waiting for some signature? I mean,
Yeah, in my mind, I was.
and if you're in court and the court is satisfied that the person's application is pending, or the court is deeming them to be allowed to appear pro hac vice, then I think you don't have a burden.
Yeah, although, so flipping it then, if the court is complaining, but still not forcing them to do something.
Well, I think that one of the issues for your client might be if the court is complaining and you're not sure that they're actually admitted to practice in the state where you're negotiating an agreement, you might be wasting your client's time and putting your client at a disadvantage by allowing these negotiations to go forward with someone who then didn't really have authority to enter into the negotiations or to resolve them. But
You could move to disqualify them to
I would
to
move,
push the issue.
I would let the court make the decision.
Yeah, in this case, the facts that I put in the hypothetical were that the person definitely isn't admitted and they've made multiple phone appearances. But,
But the court is letting them appear.
true. Well, I'm hardened to hear interpretations of 5.5 that are less restrictive than the one I had in my mind. I hope you guys are right. Because I think it puts a burden on the lawyer that is not necessarily tenable, right? Especially if the facts were different, and as Janet suggested, if you don't know, what are you supposed to do? Look up everybody's registration, although it is easy to do.
Well, but how do
But-
you know what the rules are in another jurisdiction about pro hac vice admission?
But you're in your own jurisdiction, you're in a home jurisdiction, so you do.
Should we take a question in the
Yeah.
back, Michael? Yes. There's one all the way behind you, yes.
Actually, the question is, when I am representing a client, I never ask my adversary attorney whether you are admitted or you are not admitted, or what is, where you are admitted, or what is the status of your application before the court. I just take it on the face value that when my adversary attorney is saying that I am an attorney of record, he or she is the attorney of record.
So it's sort of, the question is, don't ask, don't tell. What if you don't ask and you don't know? Do you really have to care? I mean, this gets back to my view, which is that you're not your brother's keeper. And it's one thing if you hire someone or work as co-counsel with someone, and you know they're not authorized to practice law. But when it's a lawyer on the other side, do you think you have to worry about it? I don't know.
I think it depends on what aiding the unauthorized practice is. And I sure like the more narrow interpretation that folks are suggesting.
And there's one other question? Yes.
My question really is apart from appearances in court, if you're just negotiating with someone, I mean, doesn't a pro se person, which they technically are if they don't have a lawyer, have a right to have an agent speak for them? It doesn't necessarily mean they have authority to finish a deal, but if they've authorized that person to speak for them and they've told you that that person's authorized to speak for them, to negotiate at least, if not to conclude a deal. Why do you, I mean,
So
why is
the
that?
question for folks on the webcast is, doesn't the person have the right to have someone act as their agent? Whether or not they're admitted shouldn't really be relevant. It doesn't mean that they are authorized to close the deal, as it were, but that they could just advocate on behalf and help that person out. And why would that be a problem?
Perhaps true. With this hypothetical, I made it easier because it's a person who's appearing by phone on a court proceeding. But I understand that you could potentially have, you could also have a situation where you had a family member who was providing support, which maybe is a more common thing. I think when it's out of court, there's one answer, right, that a party can designate someone to provide aid to them that isn't legal, right, that's support, versus in court where you can't appear without a lawyer or else it's unauthorized practice of law.
So Michael, can we do the last
Yes.
part within 5 minutes? And then we're going to go an extra
I sure would be
5.
happy if we did.
Okay.
To kind of shoehorn a third topic into these same facts, I chose for diminished capacity, my third example, it's on page 328, again in the role of attorney for the father. Just as this violation petition is getting going, your client tells you that they're receiving disability payments and they're disabled. And the short version of this is they're receiving help from their new spouse. They're providing competent care for the child when the child's in their care, when the child's with them. But the client, can't negotiate properly because they can't handle any stress. They can't handle any conflict. So must you reveal your client's disability in these circumstances? And perhaps I can say, in the interest of time, I want to say maybe. But let me tell you what I was thinking of when I came up with this. Given that it's a custody proceeding, your client's fitness as a parent is always an issue, and your client's ability to provide care for their child is always an issue, and the best interests of that child are always an issue. So given all of that, the chance that you can conceal a client's disability that rises to this level, which I realize might be an incredibly unusual one that might never happen in the real world, the odds that you can conceal that and get away with it, I think, are negligible. I'm hoping someone will disagree with me, because again, I'm stuck with Rule 3.3. The other rule to bring up is, of course, Rule 1.14, clients with diminished capacity. It's on page 100 of your materials. You can also think about whether you need to take protective action for your client under Rule 1.14. In the materials, there's an Oregon ethics opinion that you can reveal the disability status if there's a basis to take protective action. That opinion's at page 373 of your materials. And Bruce, should I just point out one allocation of authority and communication, and then is that Rule 1.2 and Rule 1.4, that's pages 35 and 42 of your materials, would also maybe help you a little bit figuring out how you allocate authority between client and lawyer, how you must communicate with your client, and how you would arrange for that. The last thing in this hypothetical was about whether you could make a disclosure to protect the child. Under the facts I gave you, the child wasn't in any harm, so Rule 1.6 probably wouldn't give you the ability to do that. And I just should note, if there's anybody from Nevada or Ohio out there, those states do have mandatory attorney reporting laws for a suspected child abuse maltreatment, which is foreign to us here in New York. But if you might be in a jurisdiction where, as an attorney, you need to report that a child's at risk. Not the case in this jurisdiction. And I think that was all I wanted to say on that last.
Okay, terrific. So we end with a multimedia presentation, fireworks and slides.
You turn on the lasers. Turn on the lasers. Is it up?
Yep.
Okay. Well, my two topics kind of, I was wondering if, I think last year we put some of this up front, because it's like, who is the client, and then it's at the end, and I'm going, well, but it actually works, because now it's a good summary, right? Like a good presentation that you tell them what you told them, and then you go back and forth and whatever. So we're going to go through my little PowerPoint just to cover the subjects, because the two subjects are who is the client, and then supervising lawyers and non-lawyers. All right, so we're going to cover the subject matter. There's two brief hypos. I don't know if I might save them to the end, so we make sure we cover all the materials, or we'll see if we can hit them. But a lot of them, is repetition of what the thread that ran through all the presentations is, identifying your client. It's very important. It's something that took me, when I think back in the very beginning of my going to private practice, or even starting in not-for-profit, it's something that you just kind of have to pick up. It's like this radar. Everyone says, your little antennas go up to just sort out who's the good guy, who's the bad guy. And it's just like a lot of this stuff we're sharing with you is just from years of experience. So you don't take it for granted that you know who your client is. Failure to identify them at the beginning. All these hypos with mistakes and errors is, sometimes that you didn't do that. And, clear identification, branches out and creates your attorney-client privilege, confidentiality, who to share information with, who not to. And it's for your own protection too as an attorney, because in my other program in elder law, we have, what happens to you when you violate these ethical rules. And it's great. We did that in reverse this year. We told exactly what happens to you when someone does call in and make a complaint against you. And it's really scary, to learn what's going to happen to you. So it frightens you into doing the correct thing, hopefully. So why is this important? Again, attorney-client relationship, confidentiality. You need to be able to advocate 100% for your client. And if you have split loyalties or confusion, it just wreaks havoc in all these examples that we brought up. So it's not always as black and white, particularly in an elder law practice. We have many things going on. So here's just your generic definition of a client. You can get this out of Black Law Dictionary or whatever. But in my practice in elder law, we do have many parties coming in. I think in major firms, or you're in a criminal lawyer, a guy walks in the door, I did it or I didn't do it, and you say, that's my client. But in a family type practice, in an elder law type practice, you have many players popping in. And it becomes almost, like I said, a sorting game. You have to sort through. Something's not that easy. It's not the person just sitting in front of you. You have to sift through all these people who are calling you and trying to be helpful or not helpful, or saying, this is what, I don't think you should talk to that person because she does this or that. And, you have to find out ways to make sure it's clear and convincing to everyone. And as a lot of the discussion today revolved around is retainer agreements. And a retainer agreement can announce to everybody who is the client. But sometimes, as we just discerned this morning about, having too much paperwork, too many agreements to be signed, sometimes it's just as simple as, announcing to the world that, this is my client. And I do it a lot of times jokingly with the children. The children come in and they're sitting there with me and the parent. And, when we talk about, sorting things out, if my little antennas start to go up, could be potentially a problem. I make a lot of jokes about, it's mom's money. If she wants to flush it down the toilet, it's her business. Even though if you think it's a good idea, son, that we should do this, I can tell in mom's eyes that she's ready to just jump out the window and want to kill me. So, I always side with my client. I side with the senior. And I take that intentional position just to make sure I create that bond with her, so she doesn't feel that she can't call me, that I'm not, working for her children or whatever. So there are those things, and it's not in writing, but I make it clear, and I feel that can be almost as strong as or as important as having something in writing. So these little cartoons emphasize the things that I have to deal with sometimes. Now, in elder law practice, as I said, there are many people surrounding you that you just wouldn't realize. And I'm sure in some of your family practices or in your clinics or whatever, you have these types of things coming on, but I have a little universe here. Client may actually need these people. They rely on the family, they rely on friends, caregivers, neighbors, spouses. I have ex-spouses. I have ex-spouses who divorced the person, and now they're just kind of still best friends, and they're almost living together. you know, and to the point when, like in Medicaid practice, I will often talk to them, we'll joke about it, but say, maybe you should remarry the person. Because of the benefits you can get from being the married spouse. I mean, you're virtually staying married. You just had a fight and you eventually broke up after 40 years of marriage or whatever. But, you know, the person really is like the caregiver and like the spouse. So, you know, we joke about those things. But of course, even though you have these bonds that tie and that you use in helping you do your representation and represent them adequately and properly to gather information, you do have to have a boundary that you can't cross. Where that boundary lies, you have to determine, you know, on your own. It's your job to advise the client and protect them, but you know, you just have to be careful about that. So, I find when I'm just, you know, running through a new client into the office or whatever, I do have sort of a mental checklist, I guess. It's just become ingrained in me. I have memorialized it in paper on page 403. It's just sort of, I sat down and said, okay, what are the things I start to ask about in my head, to worry about, that kind of set off little alarm bells in my head, you know, maybe for people who are new to this type of thing. And I just kind of made up a list, so you can look at that later in bed tonight when you're reading about all this stuff. And it just helps. It just helps to go through that and figure that out. So I have my hypo here that just talks about choosing the client. Should we want to tackle it quick now, or do you want to
We
go
could
through
go a
the
little
subject?
late. So
Okay, well, let's just tackle it here, because I was going to put them all to the end and then we could jump back, but this is a typical caregiver, daughter, and a changing of will, power of attorney issue, which happens constantly in my office. So you know, I guess you won't be able to discern which one of my clients this is. But Susan contacts you and wants to bring her father in to make changes to his will. She's contacting you. Right? Very common that the child is taking the proactive mode here. Susan says, you know, don't worry, I'm going to take care of his legal fee because Dad's real tight with money. He'll never want to come if he has to pay. And you go, fine, because, you know, in the greater scheme of things, it's important for Dad to come in and see an attorney than to just sit home and let his entire world go to pot because he didn't do wills and power of attorney and healthcare proxies and so on. And then, you know, in talking to her, you learn that Dad's been living with her for many years now, and it sounds great, whatever. So they come in to your office. They seem very close, loving, no problem. And then he starts to, you know, he opens up and starts to tell you what they want. Well, hopefully he says it, wants to do. And, you know, you do have to listen carefully. That, okay, so, you know, Dad's there, he's telling you about his 3 children, and now he's kind of he wants to cut out the 3 children, or, you know, of course he wants to, you know, lean towards the child he's with, all very common things, and wants to name Susan a power of attorney, blah, blah, blah. You know, you see the situation. All right, so the first question is, who is the client? All right, as I've emphasized before, here I would say, as I usually do with the polling too, but I know we don't have time, and we're not going to do it today anyway, that the client is the father, okay? Now, of course, the question comes up, who is paying the fee? And you know, that can cause some ethical issues. I mean, I think it is discussed. If you read it, I included in your materials, NALA, National Academy of Law Attorney, has some aspirational standards. As you said, most of these ethical things are all aspirational, right? Until you violate them, then you're in trouble, right? So you know, I think it's good if you have an elder law practice to read these kind of aspirational standards, because they actually do delve into and explain and analyze to the best of their ability these difficult issues that come up that are not covered probably in the regular New York professional, you know, ethics rules or ethics rules in your state. So, you know, in here, you know, in the NALA article on page 408, identifying the client, they do talk about, you know, engagement letters are important and, you know, expose potential conflicts. Sometimes, you know, you can discuss having joint representation type agreements they talk about, just like in a spousal situation. I've never done those. I know this topic was touched today, that, you know, should you have something in writing about these 2 different parties that are sitting there and maybe you have to disclose to the other party or whatever. I've never had to do that personally. I know that it's, you know, it sounds like a good practice on paper, but I've never had to really throw that on the table. You want to, describe when the relationship will end and educate those around you, whatever. The paying of the fee is discussed in the materials, and basically, the materials basically will come down to the side that it doesn't matter that it's the child paying the fee, as long as you've designated and made it known, and you want a waiver from the parent that it's okay that the parent's paying the fee and that they're the client, so that there's no miscommunication here, because of course the daughter may feel that in writing the check that, well, I'm paying the bill, so you need to share information with me. That has to be made clear up front, that the child is not the client, and that you do want to have the father signed in the retainer or some kind of waiver saying that this is all clear to everybody. Now, is there a reason to have a retainer? Here, as we said, we're talking about across the country here, but in New York State, we do have a requirement that you only have to have a retainer if it's over $3,000. I would say I don't even look at that. If I think it warrants it, we have a retainer agreement just to have something memorialized. So I don't really look at the dollar figure. I look at the complication of the issue. What could you have done to avoid trouble later? Your antennas should have gone up right away when you hear that they're cutting out children. All right. Soon as there's money involved and there are people who are going to be cut out, you have to just immediately and absolutely I would have, or I do ask the child to leave the room so I can speak to father alone. In those cases, I think only on one or two occasions that I've had problems with that, meaning that the person who I asked to leave is kind of upset and insulted and so on. Usually just by joking around or whatever, I can get around that and they leave the room. And luckily in those cases, the parent or the significant other has repeated exactly what they want to do and had any problem appointing that person power of attorney or putting them, with their will or whatever. So that has not caused a problem. But I'm not sure what I'm going to do if, if that person doesn't want, I find that there's undue influence, then I'd have to kind of lower the hammer on that person and kind of exclude them. So, I think in designated the client, in these kind of situations, you do have to meet with them alone. I know that has saved me a lot of grief in the past, and it's amazing when you're called later on to testify about someone's competency, and you bring up that, no, I met with the client alone, and everything I spoke to them about is attorney-client, and I cannot disclose that. It really works, like in law school, when you read about it, right? That's it. You have to go to court to get me to pry me open to say what we talked about. And it's always amazing to me that it does work, but you do have to take that extra effort to do that, because if you can't say that, then that's it. All bets are off, and you have to just disclose all confidences. Okay, any discussions about any weird things about clients, choosing client? I think it's pretty clear after we've covered all these through the different hypos today, okay? Now, the second subject that I delved into this year is supervision of lawyers and non-lawyers, which is something that I never really thought about too much, and I guess we all rely on our paralegals and our associate attorneys and so on in practice. Here in New York, these are the rules that we rely on, and you can see here, and as you'll see, I have some materials in here from New Hampshire and Massachusetts and so on, that it's pretty. I think you're going to find that it's pretty uniform throughout the country. These kinds of supervisory responsibilities. The New York rules are found on page 159, and like I said, I'm sure if you pull out your own state responsibility rules, you'll see similar things. That there's responsibility. That we have 5.1 responsibility of law firms and partners and managers of supervisory attorneys. I never read these things because I never really had to be in a large practice that I had to delve into this. 5.2 responsibility of subordinate lawyers. 5.3 lawyers responsibility for conduct of non-lawyers, and a lot of us use non-lawyers. And 5.5 unauthorized practice of law. And that's a big one, particularly here in New York. We've been having, at least in the elder law bar, we've been having a lot of discussion about this because there are many, it's called, the word for them, non-lawyers out there who say, why are you seeing an elder law attorney to do a Medicaid application? I can do it for you for half the price. And, lawyers charge big fees and, whatever. And, and that kind of offends us, elder law attorneys. And any attorney who's out there, I guess. And I guess in thinking about why, beside money, right, to save money, of course, why you go to a lawyer, not a lawyer, because I guess we are bound by these ethical opinions. And if we do something wrong, you can call the ethics board and make a complaint and have us investigated and disbarred or whatever other sanctions that can be put upon us. So I guess that's the one thing. You have some recourse, I suppose, if anyone else wants to chime in with some reasons. So let's look at 5.1. 5.1 deals with responsibility of law firms to manage others. Well, basically, in summary, the rule, basically the buck stops with you. I mean, you're the supervisory attorney. It's basically vicarious liability on you, all right? If you had authority over the other attorney, and even this, extends to non-attorneys, your paralegals, your secretaries, your staff, you cannot just turn around and say, that you didn't know about it. And basically, in the rules, basically it's all a reasonable standard. Okay, it's not that harsh, it's not that strict, it's not that laid out, but what did you reasonably know? What would a reasonable attorney in supervisory role take? And so on. And also what I've read in the materials that you'll see behind my hypos is that it varies on the size of your firm. Right? I think someone mentioned that today. If you're in a solo practice, it's much more liberal. Just like when you're doing your professional liability insurance, they ask you, do you have conflicts checks, right? I think in a large firm, you have to show all of the computer programs and explain what you're doing, and you're circulating memos to all the partners or whatever. In a small practice, 1-2 attorneys, you don't have to have as firm a practice. It just you kind of hopefully you remember your clients, and did you ever represent this person before, or is there a conflict that you can ask about? So you can just do it a little more liberally. So the rules do take into account the size of your firm. So as I reemphasize here, what is a supervisory responsibility? Reasonable efforts to have others conform to the rules. You do have to have some, basically, another theme that runs through it all is education. Education of your staff, of other attorneys, of what is proper and improper. Because, you're the attorney, and my staff often turns to me and says that. They go, well, you're the attorney, you have to tell them which way we're going to go, or which way we should go. And if you find out that there's something wrong, it's like, I guess, like subsequent remedial measure, you have a duty to take remedial action. All right. I mean, that is the biggest fault. If you found out and didn't put some new practice in place that would change what's going on in the firm, that's probably the bigger violation than the violation itself. So we're going to talk about next what's the duty between duty to and between other lawyers, and what you knew or should have known. And basically, you'll see in Massachusetts on page 455. I have, there's an article, as Bruce mentioned the title, Thy Brother's Keeper. And there's a nice article there written by the I think, disciplinary attorney up there about, your responsibilities in failure to supervise your other attorneys under you. So that's good reading also. And again, that's in Massachusetts. Okay, obligation of lawyer subordinates is 5.2. Basically, associates must think for themselves. All right, you cannot employ the Nuremberg defense. You can't say, well, the partner in charge of this case said it was fine to do this. I did it. so I'm absolved. Okay, you can't do that. You do have to. I mean, in practice, is it that easy to do that and override the senior partner or someone who's supervising you? No, but this is out there, and I guess if you had to, seek guidance from the office of the bar council of your state or whatever, I guess you could make a private phone call. I don't know how you actually implement that kind of thing. If you find that there's something really not going right. I mean, this is a script of a movie, right? All these movies that you watch about lawyers, right? What do you do if something's going wrong inside the firm? And
Oh, Morgan Freeman.
go Morgan Freeman in, right? Sell the rights to your story, and then go into hiding, and get out of the law practice, right? Because no one's ever going to hire you again. So it's just you should know about these rules. We could go on hypothetically forever whether it's practical or impractical to implement them or not. Now, 5.3.5 subject, basically what you're going to see is, and what's good, a good article to read, subject on page 466 in New Hampshire, there's ethics opinion in New Hampshire that covers this subject. Basically, that paralegals are not lawyers, and I bring this up in my example too, and therefore, since they're not holding a legal license, and they're not registered and licensed and passed the bar, that they cannot do unauthorized practice of law, and that's what you're fearful of. That you don't want to give the impression to the client that your paralegal is a lawyer, and that they can practice law. Basically, professional judgment is left to the lawyer, not to the attorney. It's okay, and it's also discussed in the New York opinion I have here, that delegation is perfectly recognized by all ethics opinions, that we delegate a lot of work to our paralegals and assistants, right? Sometimes you can't live without your paralegal. They probably know as much, if not sometimes more than you, on certain subjects. But you do have to supervise them and not give the impression that they have any right to practice law, all right? And as it says in the New Hampshire opinion on page 466, learning alone is not enough. There's a good quote I found here, that just because your paralegal knows more than the attorney, then they learned a lot, it's not enough. That you have to rely on the attorney's license and not let the just like as it says here at the bottom of my slide, would you let a staff person sign your name to a pleading without you having pleading, or would you let them do something without you having reviewed it? It's as simple as that. Okay. Now, third parties. A lot of us use outside people. I use geriatric care managers, social workers, doctors, accountants, other attorneys, and you have certain necessary third parties in your practice that help you in assisting the client. But the question that brings up, and this is kind of a little bit outside of the realm of my subject, is that does that breach the attorney-client relationship? Because you brought in this third party outside, and all these people are circling around. So you have third party involvement, and there is a very good article on page 445 of your material that discusses the federal law on third party involvement and extension of attorney-client to those individuals. All right, and it breaks down to these two different schools of thought, two types of cases. One is the Covell case, and one is the Copper Mountain antitrust case. And like I said, if you read these two articles, the article I included, it's a nice summary of the two. But basically, the Covell one's very, very clear cut that if you absolutely have to use this person like a translator, that's the catchphrase, because the person only speaks Chinese and you can only speak to that person because they only speak Chinese, that then the attorney-client privilege is extended. Because they help you understand non-legal concepts and it's spelled out. But you still should spell these things out in your engagement letter, they say, of course. Now, under Copper Mountain, it's the definition is functional equivalent of a firm employee. It's that you don't have enough staff or the person on your staff to accomplish that task. So therefore, you brought someone in to fulfill that, on a part-time basis or on a subcontract basis. So they're a de facto employee. That one I have a little more hard time wrapping my head around. But those are the two kinds of tests you need to employ and impose on these situations to determine if the attorney-client privilege attaches. And I think you have to educate your third party about this, if there is a third party, if there is attorney-client, because they're just working for you. They don't know that, everything that transpires between you and the client or what they learn is subject to attorney-client privilege.
So rather than doing the hypo, since we're a couple minutes
Yeah, we're over now.
my suggestion is everyone should do it for independent study credit.
Okay.
Because I think
Yes.
we packed in a ton of effort.
We did, and
into-
everything's in writing in there. You can read about it.
Yeah.
It's great. Okay.
So I want to thank the audience. I want to apologize for not getting to all the questions on the web thing, but thank you all for your attention. I want to thank the members of the panel for their insights and for putting the materials together. And I hope you'll all come back next year, same time. Thanks again.
Thank you.
I'd like to remind all of you, please don't forget to sign out so you can get your CLE credit. Please take a moment to fill out the evaluations on the iPads as well. They're really helpful to us in planning future programs. If you wouldn't mind all sharing with us your thoughts on our pro bono programs here at PLI, that is the yellow sheet. Please leave that at the registration desk on the way out. And finally, if Mr. A.J. Bosco is here, there's a book for him at the registration desk. Thank you all very much for attending today.